Hey, peace and love, Ready Nation. This is Tamara T. Bush coming to you with another video. Just something really quick that I wanted to go over, something I was looking at today that I thought would be of value to you all. Um, let me just give my little disclaimer. So you know that any information presented on this channel is not to be construed as legal advice. Definitely CYA, cover yourself when trying to execute any strategies that anybody, not just me, are providing clarity to you on. So this is sort of interesting because what's happening is a lot of people are receiving summons in the mail. They're being sued. There's a lot of things going on right now in terms of these lawsuits, right? And so usually what happens is when a person receives a summons in the mail, they really don't know what to do. So because they don't know what to do, they do nothing. And so then what happens is you find yourself in a situation where you do not have the proper tools in your tool belt in order to defend yourself against a claim that a company or anyone is asserting against you, right? And we all know that it's not really you. We know that they're asserting a claim against the legal person. They're asserting a claim against the estate. But because a lot of us don't know who we are and we cannot, it's hard for us to wrap our minds around the separation between the natural person and the legal person. We believe that they're asserting a claim against us, right? And so, it's important to, just sort of understand what that clear line is between the natural person and the legal person so that we know how to properly respond when and if we receive something like a summons or a lawsuit or any sort of court paperwork in the mail. But the one thing that I can tell you is do not ignore it, because if you ignore it, that is an immediate acquiescence um, to the claim that is being asserted against you. That means that you agree. You actually agree with what they're saying. And so, it's the same thing that happens when you receive a collection letter in the mail, any sort of claim that's being asserted against you. If you ignore it, you do in fact acquiesce or agree to the claim that is being asserted. So this right here I thought was pretty interesting, just to sort of give you a foundation to look at when you're needing to defend yourself against the claim when you're being sued or you're being served, right? So this is Rule 12 of the Federal Rules of Civil Procedure. You can find these up on the Cornell Law website. You can literally just Google it, right? And it's going to take you right to the website. So this is Rule 12, defenses and objections, when and how presented, motion for judgment on the pleadings, consolidating motions, waiving defenses, pre-trial hearing. So, it's amazing to me because a lot of people, they know that they've been violated, but they may not necessarily be able to zero in on how they were violated, nor do they know how to properly defend themselves if they're the defendant in the situation, and then also how to assert themselves if they are the plaintiff in a situation, right? So this is important information that we need to know. So it sort of gives you some procedures that you need to follow when defending yourself against a claim that they're bringing against you, right? Okay, so let's read. Time to serve a responsive pleading. Okay. In general, unless another time is specified by this rule or a federal statute, the time for serving a responsive pleading is as follows. Now, remember, this is if you are being served or you're being sued. So this is telling you that you have to respond within a specific time frame in order for your response to be um, for it to become a part of the record of the case, right? So it says here, a defendant must serve an answer within 21 days after being served with a summons and complaint, or if it has timely waived service. So now, if you have not filed any sort of paperwork where you're asking for them to waive um, uh, the process of service, then this is going to apply to you, right? So it says, if it has timely waived service under Rule 4D within 60 days after the request for a waiver was sent, or within 90 days after it was sent to the defendant outside of any judicial district of the United States. A party must serve an answer to a counterclaim or a cross-claim within 21 days after being served with the pleading that states the counterclaim or a cross-claim. A party must serve a reply to an answer within 21 days after being served with an order to reply unless the order specifies a different time. Right? Now, there was something interesting in here that I wanted to point out to you because it literally gives you the types of responses that you can assert if you're being sued, right? So it says how to present defenses. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. So basically what they're saying is there's only so many ways that you can respond to a summons or respond to when you're being sued, okay? It says, but a party may assert the following defenses by motion. So it's telling you that you have to make the motion. Now, this is the at-law side of things. This is the public side of things. This is the United States jurisdictional side of things. So anytime that you're going to go at it in the court of in their court, now you know what I'm saying, their court, you're going to fight a matter, it's literally giving you the types of responsive pleadings that you can submit. Lack of subject matter jurisdiction, okay? That's number one. So what does that mean? That means that you have to argue that there is no subject matter jurisdiction in the matter. You have to actually argue that, right? Lack of personal jurisdiction. You have to be able to argue this. Improper venue. You have to be able to argue that. Insufficient process. You have to be able to argue that. Insufficient process of service. Insufficient service of process, excuse me. You have to be able to argue that. Failure to state a claim upon which relief can be granted. All right, you have to be able to argue that. So let's say, for instance, you're being sued by a credit card company, right? And so you know that pursuant to 18 U.S.C. 8, that all debts are the obligation of the United States. So you know that you don't technically owe that money, right? So when you're looking at failure to state a claim upon which relief can be granted, this is a good position to come from, especially if you're arguing that it's not your obligation to pay. So you want to sort of build this out, right? You would respond, your responsive pleading would be failure to state a claim upon which relief can be granted, right? But you're going to delve into your argument in terms of the statute as to why that is so. And you have to, you know, ensure that you can stand solid on that positioning in terms of your defense, right? Because it's not enough to just state the statute. You have to dig into it and state the reason why that applies to the situation in terms of that lender coming against you, asserting the claim, or they fail to assert the claim upon which relief can be granted, right? So you have to be able to really get in there and delve into that and make it applicable to your specific situation while quoting the statutes in a way that the court can understand the position that you're coming from, right? Okay, failure to join a party under Rule 19. It says a motion. Now, number 7 is definitely a little bit interesting because when you click on Rule 19, and you look at the definition of joinder, because I looked it up, right? It says when the claim of parties in one lawsuit are joined. Okay, so back to what I was saying earlier is that if you know that you are separate from your legal person, you are a natural person that was assigned a legal person at birth, and you look at the terminology of what this definition describes in terms of the parties, right? then if someone is bringing a claim or asserting a claim against your estate and you know that it's not you, technically you're a third party to the transaction, or you're a third party to the lawsuit, right? Because like I said before, they're asserting a claim against the estate. They're not asserting a claim against you personally, but because we haven't identified that separation and we have not expressed that separation in terms of the paperwork, we think that they're suing us specifically when that's not the case. So the joinder of the parties, when the claims of the parties in one lawsuit are joined, this can potentially open up the door for you to assert a claim against your own estate so that you can step in and sort of provide those instructions to settle the matter for all parties, including yourself, right? Because again, they're asserting a claim against the estate, not you. So we want to get into the habit of recognizing that separation between ourselves and the legal person. Remember, your straw man is your legal person, and your straw man is your estate, right? That's your SS, that's your BC. So we have to get used to the idea that that is a totally separate entity from us, and that we are really coming into the jurisdiction as a foreign party to the action or the transaction or whatever the thing is that is going on. But you have to be able to express that in your paperwork for that to be valid in a court of law, right? So this is very interesting. I would definitely recommend going back and studying Rule 19, right? Because it says persons required to be joined if feasible. Now it says if feasible. So when I look at that, I'm thinking in my head, okay, you have to really be able to argue this. That means you have to be studied up and you want to be able to, thoroughly express um, this in a court of law to where they're going to understand where you're coming from, right? Okay, so number one says required party, a person who is subject to service or process and whose joinder will not deprive the court of subject matter jurisdiction may be joined as a party if, in that person's absence, the court cannot accord complete relief amongst the existing parties. Interesting. Interesting. So if you're stepping in to sort of assign yourself as a third party to a court case for the purpose of being able to grant relief to all parties involved, then I would think that the court cannot accord complete relief without um, either the authorized representative or some other party of interest stepping into that particular situation, giving very specific and explicit instructions to the court to grant relief by pulling those funds out of the estate so that they can settle all matters relating to the estate and satisfy the claims of all parties, right? That's just how I would look at that. I know, like I said before, it's hard to wrap our minds around that, but sometimes you just have to talk it out and really, really know and understand what some of your options are in terms of granting relief when you're being sued. Because I know that a lot of the times, we're going in as the plaintiff because we know that we've been violated in multiple ways, and we're trying to go and state a claim upon which relief can be granted ourselves because we need relief too. But think about it. If someone is suing you, someone is asserting a claim against your estate, do you not also have the option to receive relief from your estate in that very same case? I'm just putting it out there. It's just something to think about, something to ponder on, right? Because I want you all to look at this from another perspective. Okay, so what does B say? B says that person claims an interest relating to the subject of the action and is so situated that disposing of the action in the person's absence may, as a practical matter, impair or impede the person's ability to protect the interest. That's interesting. Or leave an existing party subject to substantial risk of occurring double, multiple, or otherwise inconsistent obligations because of the interest. Y'all got to think about this. I want y'all to go back and read this because there is something to be explored here. There's definitely something to be explored. Because the thing of the matter is that they know very well that they are tapping into your estate to grant relief, right? Now, the attorney of record, who, whatever attorney is defending, the lender or the company, whoever's suing you, they are not going to add a third party of interest to the estate, right? Even though they know that you are not the legal person that they're asserting the claim against. But it's not in their best interest, it's not in their best interest to bring in a third party, such as yourself, such as the natural person, right? It's not in their best interest to do that, because at the end of the day, they're just looking to get relief. They don't really care where the money comes from. They just know that their client needs relief and they're going to get it however they can get it. But the thing of the matter is when you're stepping into court and there is no real party of interest, you fail to add the real party of interest to the case, because the legal person is just the entity that is going to grant relief. But if there are no instructions on the table, then how are they going to know exactly how to do that? How are they going to know how to do that, right? So the real party of interest, in my opinion, should be added onto all cases. And it's sort of kind of like if you go into a situation and you don't add yourself as a party of interest to the case, they're almost going to look at you as if you are incompetent, right? Because there are certain things that they're going to be looking for up front to see if you know what you're doing, right? And so that is going to take you back to knowing that you are not the entity that they're asserting the claim against. It's the legal person, which is not you. We have to, really, 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 really get that into the back of our minds, right? Okay, so let's scroll down. So joinder by court order. Okay, that's fine. Yeah, but the court is not going to order the natural person as a party to the transaction. That's never going to happen. You would have to do that. You would have to do that, right? All right. Um, when joinder is not feasible, if the person who is required to be joined, if feasible, cannot be joined, the court must determine whether in equity and good conscience the action should proceed among the existing parties or it should be dismissed. All right. The factors for the court to consider include the extent to which a judgment rendered in a person's absence might prejudice that person or existing parties. And you are most certainly going to be prejudiced, right? Because you're coming in as a third party to the case, trying to grant relief. And if the court does not allow the joinder, then um, it's going to hinder you from being able to provide the proper instructions for the estate to grant relief to yourself as well as those third parties. Because remember, the legal person is supposed to protect you in a way, right? Number two, the extent to which any prejudice could be lessened or avoided by protective provisions in the judgment, shaping the relief or other measures, whether a judgment rendered in the person's absence would be adequate, and whether the plaintiff would also, or whether the plaintiff would have an adequate remedy if the action were dismissed for non-joinder, right? All right, so you all go back and read this because, like I said before, I'm just here to plant the seed, but you all have to go back and read it and explore it and really make it make sense for your situation. I highly recommend that if you are going to be involved in any sort of administrative process, these are some of the things that you're going to have to know. You're actually going to have to know the rules of civil procedure. Now, these are the federal rules, so you definitely want to go and read up on your state rules of civil procedure, because the states may have adopted these rules, but it may be a little bit different. So you're going to want to go and read those. Part of the issue that I'm seeing with people is that I know that they want and need relief, be it monetary, equitable, whatever that relief is. Part of the issue, a lot of people, they send in all this paperwork, and then when the companies don't do what it is that they want them to do, They get frustrated, they stop, they're like, oh, what should I do? They came back and said that this was verified, or they came back and they ignored my paperwork and they didn't give me a proper response. When I sent them a validation letter, they sent me a copy of statements. Like, all of these issues that people are having with getting any sort of relief partially is because they don't know what the proper administrative process is. And a lot of people are failing to understand that every single thing that you do with these companies in terms of sending them the letters, whatever that looks like, is going to be part of your court case if you do decide to move forward and sue. The problem is that a lot of people don't know how to go about suing, or they just don't want to. They just think that the companies are going to bend over backwards, give them everything that they want on the first try. And that's just not realistic. So I hope that you all are empowered. Don't be scared to go up against these people. Once you do it the first time, the second time, the third time, every single time you do it, it's just going to get easier and easier and easier and easier, right? So you have to be willing to sue. All roads lead to either arbitration or litigation. So you definitely have to be able to sue, because you're not just going to get a check in the mail from sending one letter, right? You're not just going to get um, that item removed from your consumer report just by sending one letter. Everybody's situation is different. What works for one person is not necessarily going to work for another person. So everything that you do needs to be customized and tailored to your own specific situation. Hear me, I'm going to say it again. Every single thing that you do should be customized to your own individual specific situation. Use a template only as a guide. Nobody should be copying templates word for word for word. When you do that, you're causing yourself a disservice, and you are defeated before you can even get started, because whatever party you're trying to assert that paperwork against, they can see you a million miles away. They can already see that you're coming, and they can anticipate what your next step is going to be. And they can almost dismiss you because they already know that you're trying to come in as like some sort of sovereign citizen or whatever it is that you're calling yourself, especially if you're doing any of this without any form of status, right? So I just wanted to hop on here to show you all that there is a process that you have to go through if you are seeking any sort of remedy. If you are seeking any sort of remedy, regardless if it's from the FDCPA, the FCRA, Truth in Lending, whatever that looks like. If you are the defendant or if you are the plaintiff, there is always a process in place that you have to follow to be victorious in what it is that you are seeking. So I'm here to empower you to study, pull these things up, read them. Y'all, we gotta read. We have to, because it is hurting us so bad that we don't read. We got to pull this stuff up, and we got to look at it, and we got to read it so that we fully know and understand what we're supposed to be doing. We have to read, y'all. We got to read. You can't get past it. So, like I said before, this is the Civil Rules of Procedure, Cornell Law. I will make sure that this information is linked down into the uh, description section of this video. See, look here. It even talks about commencing. That means when you are going to pursue an action against someone. It's telling you. It's telling you. It tells you what to do. These are like the actual procedures, y'all. These are the actual procedures. It tells you about service of process, right? Talks to you about privacy. Talks to you about motions. It tells you the type of pleadings that are allowed. Look, it tells you only these pleadings are allowed. A complaint, an answer to a counterclaim, an answer to a cross-claim, a third party is literally giving you what you need. An answer to a third party complaint, if the court orders one, a reply answer. Check this out. A request for a court order must be made by motion. Come on, y'all. So when you're going in and you're trying to seek a summary judgment, because some of you have gone through the administrative process and you have all of your evidence, you have all of your paperwork in order and it's on point, but you need to go and get a summary judgment. Summary judgment is when you can request that the court make a ruling on your paperwork without having to go through any sort of court proceeding or a trial, right? It's literally telling you what you need to do. It tells you. It tells you. Yep, court order must be made by motion. The motion must be in writing unless made during a hearing or a trial. Just like on TV. You know how the attorneys say, Your Honor, I motion to XYZ. This is what they're talking about. I know a bunch of y'all are out there watching court shows and criminal shows and stuff like that. Y'all should know this stuff by heart. As many of y'all sit up there and watch hours and hours and hours of murder shows and court shows and stuff like that. A lot of the stuff that's going on in TV shows is real, right? It also says a request for a court order must be made by motion. It must state with particularity the grounds for seeking the order. So what are your grounds? And then you also have to state the relief that you're seeking. So a lot of you are not attaching the necessary value that you're seeking in relief. And you just need to be able to justify it. If you can justify the value, put it in the paperwork. What are you asking for? Are you clear on what it is that you're asking for? And I get it. A lot of people, we need relief now, but we have to take the time out to properly map these things out so that when we do go up against these people, we can get what it is that we're asking for. Right? Disclosure statements, general rules of pleading, form of pleading. Look at all this stuff. Signing pleadings, motions, and other papers. Come on. Counterclaim or cross-claim. Third-party practice. Timing of summons and complaint. Look at this. A defending party may, as a third-party plaintiff, serve a summons and complaint on a non-party who is or may be liable. Come on now. This is literally what I was just saying when we were looking at the other rule. A defending party may, as a third-party plaintiff, so basically what you're doing is you're converting yourself from a defendant to a plaintiff against your own estate. That's how I would look at that. A defending party may, as a third-party plaintiff, serve a summons and complaint on a non-party who is or may be liable to it for all or part of the claim against it. Come on. Y'all, it's all in here. It's in here. The plaintiff may assert against a third-party defendant any claim arising out of a transaction or occurrence that is the subject matter of the plaintiff's claim against a third-party plaintiff. Y'all got to go read this stuff. Y'all gotta go read it. Yep. Talks about class actions, derivative actions. This rule applies when one or more shareholders or members of a corporation or an unincorporated association bring a derivative action to enforce a right that the corporation or association may properly assert but has failed to enforce. The derivative action may not be maintained if it appears that the plaintiff does not fairly and adequately represent the interest of shareholders. Okay, so didn't we speak about this in one of the other videos where we spoke about credit? Let me see if I can find it, y'all. It's in the UCC. Let's see. It's in one of these definitions, right? I don't know if this is it. Let me see if I can find it for y'all. Because it's hidden. It is the securities intermediary. I want to say it's somewhere in there. Here it is right here. So it's a security. Okay, so a security except as otherwise provided means an obligation of an issuer or a share, participation or other interest in an issuer or in the property of an enterprise of an issuer. Okay, so who's the issuer? Who's the issuer? An issuer. With respect to an obligation or with respect to an obligation on or a defense to a security, an issuer includes a person that places or authorizes the placing of its name on a security certificate other than as authenticating trustee, registrar, transfer agent, or the like. Okay, so basically what that's telling me is that we are the ones that's issuing the securities, right? We are issuing the securities. These securities are being held by the securities intermediary, okay? The securities intermediary is a clearing corporation. Clearing corporation, a person that is registered as a clearing agency under the federal securities law. Okay, so let me go back to this. Where was I at? Let me see. So this says derivative actions. This rule applies when one or more shareholders or a member of a corporation. Okay, so let's look at shareholders because this is the key. This is the link to what I'm trying to explain. It says a shareholder. It says a shareholder. A shareholder, right? So what is a security? An obligation of an issuer or a share. Okay, so who's the shareholder? Who are we talking about is the shareholder? I want y'all to think about this for a second. Think about it. Think about it. Just think about it. The security is an obligation of an issuer or a share, participation, and other interest in an issuer or in a property or an enterprise of an issuer, which is represented by a security certificate. Security certificate means a certificate representing a security. Security entitlement means the rights and property interest of an entitlement holder. Okay, so we spoke about different securities before. We spoke about a certificated security and an uncertificated security before on this channel, right? So when you go back and you look at who the shareholder is, if the shareholder is an individual that is issuing or holding, shareholder is an individual that is holding a security, holding a security, right? Holding a security. It says an obligation of the issuer. Okay, so the issuer is the individual that's placing or authorizing the placing of its name. So are you not authorizing or placing your name on the documentation that's being issued by the securities intermediary, which is your bank, other than as authenticating trustee, other than, so you're not signing anything as a trustee. See, authenticating just means to sign. That's all that means. You're not signing as a trustee. You're not signing as a registrar. You're not signing as a transfer agent. You're not signing as any of those things because it says other than as an authenticating trustee, right? We're the ones that's issuing the securities with our signature, y'all. That's us. That is us. Creates a share, participation, or other interest in its property or in an enterprise or undertakes an obligation. Okay. So who's undertaking the obligation? Aren't you the obligor, or your legal person is the obligor undertaking the obligation? Directly or indirectly creates a fractional interest in its rights or property. Anytime that you go and complete a consumer credit transaction, basically what's happening is that you are granting the rights to the credit of your estate to the company that you're doing business with. You're signing over interest in your estate. You signed the documentation. When you signed the documentation, uh, you created the security, you created the instrument. But then what we do wrong is what we don't realize is that we take it and we assign it back to that company, granting them the rights, granting them the security interest in the property. It says if the fractional interest is represented by a security certificate, which it is, right? Which it is, becomes responsible for or in place of another person described as an issuer in this section. Y'all got to go back and read this. Go back and read it. I'm just trying to get it to click for you. Just trying to get it to click. Go back and read it. All right. So I will make sure that this link is down in the description of this video. This is literally giving you all of the procedures that you need to study and follow. And let me tell y'all, I'm gonna just tell y'all straight up, if y'all are not willing to study this, don't do the administrative process, because you can't, unless you're going to arbitration where you don't have to know any rules or laws or anything. Well, you still need to know laws, how you were violated. But in terms of how things should go, um, the path least resistant is to go to arbitration. But a lot of y'all haven't even pulled out your credit card agreements, your loan agreements to even see if that company will arbitrate with you. So people are blindly doing the administrative process without really knowing what the end result is going to be or what they expect the end result to be. So, and that's really part of the problem. But yeah, I just wanted to, hop on here and just go through this real quick, because these are things that make you go, when you start digging into these codes and these procedures, a lot of this stuff is going to jump off the page to you. And it's going to become self-evident that you need to study, because there's something hidden in here that could potentially help you get the remedy that you're seeking. All right. So again, this is Tamara T. Bush. I just wanted to hop on and give you all some more clarity in terms of how to move forward or how to respond in terms of summons or anything that you receive that's going to take you into their jurisdictional courts. I hope that this information was helpful. Definitely like, share, and subscribe. I want you to share this video out to anyone that you believe it's going to benefit. Like the content, because I give a lot of free information on this channel. Definitely need to get the likes up. I appreciate you all for taking the time out to spend time with me on this channel. I definitely appreciate you. If you are not in the Ready Nation Facebook group, get in the Facebook group. We're having live Q&As. A lot of people are getting some great results. People are getting their questions answered. It's a really nice community to be in, because you want to do this with people that are like-minded. Um, you don't want to be out here by yourself, because it can get very overwhelming very fast. Um, you just want to have someone available that you can bounce ideas off of, right? And share your paperwork with. Also, I'm going to be I will be doing a year-end sale, an end of year sale. for 2022. That will be starting this week. So definitely keep your eye out for the link for the discount code on this channel, because I want to go ahead and make sure that everyone is good getting into the end of the year. And that's, I said it before the other day in my other video. It's like, we're already at the end of 2023. If you have not already, or 2022, if you have not already started to plan for 2023, you are definitely behind. And when I say plan, I'm talking about your finances. I'm talking about getting your family straight, getting your assets protected, and really, really getting organized, so that you can hit the ground running the beginning of the year. All right. All right. So I will see you all in the next video. I appreciate you. Again, this is Tamara T. Bush, and I will see you all soon.